The courtroom was quiet, too quiet. The kind of silence that settles in just before something unexpected happens. Fluorescent lights hummed overhead, casting a dull glow on rows of wooden benches, scuffed floors, and a judge's bench that looked more worn than wise. It was just another Tuesday morning in County Courtroom 3. The kind of place most people only see if they've run a red light or missed a payment. Nothing fancy. Nothing dramatic. Or so everyone thought. An elderly man walked in slowly, leaning on a wooden cane. His coat was old but clean. His shoes polished just enough to show he cared about how he presented himself. He moved with care, not because he was frail, but because age had taught him there was no rush in life, especially not in a place like this. He took his seat without a word, nodding politely to the clerk who called his name. Up on the bench sat Judge Harold Reeves. He was in his early 50s, sharp-eyed and sharp-tongued, the kind of man who believed the gavel gave him more than authority. It gave him the right to cut people down if they didn't meet his standards. He'd built a reputation for moving cases quickly, sometimes too quickly, and for showing little patience with what he called excuses. To him, court wasn't a place for stories. It was a place for rules and consequences. When the elderly man's case was called, he stood carefully, gripping his cane with both hands. The charge was simple: failure to signal a turn, a minor traffic violation, the kind that usually ends with a small fine and a warning. But Judge Reeves wasn't in the mood for leniency that morning. "State your name for the record," the judge said, not looking up from his notes. The man gave his name clearly, voice steady despite his age. "And do you understand why you're here?" the judge asked, finally glancing up with a look that bordered on boredom. "I do, Your Honor," the man replied. "But I'd like to explain." "Explain?" Judge Reeves cut in, eyebrows raised. "You ran a stop sign. The officer's report is clear. There's nothing to explain." "It was actually a turn signal violation, not a stop sign," the man corrected gently. "And I believe there may have been a misunderstanding with the officer." "Are you questioning the officer's word?" The judge snapped, sitting up straighter now, his tone sharpening like a blade. "No, sir. I'm simply asking for a chance to share my side." The courtroom seemed to shrink. A few people shifted in their seats. Even the bailiff glanced toward the bench, sensing the shift in the air. Judge Reeves leaned forward, fingers steepled. "Let me make this very clear," he said, voice low but loud enough for everyone to hear. "This is not a debate club. You're not here to argue. You're here because you broke the law. And if you keep wasting my time with excuses, I'll charge you with contempt." A murmur rippled through the small crowd. Contempt over a turn signal? The elderly man didn't flinch. He simply nodded as if he'd heard this kind of thing before. "I understand, Your Honor," he said calmly. "But due process allows me to present context." "Due process?" The judge let out a short, dismissive laugh. "You've been watching too much TV. This is real court, not a courtroom drama. Now either plead guilty or I'll add the contempt charge right now." For the first time, the man paused, not out of fear, but out of disappointment. He looked around the room, not with anger, but with a kind of quiet sadness, as if he'd seen this kind of thing too many times before. Then he turned back to the judge. "Your Honor," he said, voice still calm but firmer now. "You're within your rights to hold me in contempt, but only if I've actually shown disrespect. I haven't raised my voice. I haven't interrupted. I've simply asked to be heard, which is my right under Rule 42 of the State Judicial Code." The room went still. Even the clock on the wall seemed to tick louder. Judge Reeves blinked. "What did you just say?" "I said Rule 42, the man repeated. "It outlines the conditions under which contempt can be charged. It requires clear and willful disrespect, not a polite request for clarification." The judge's eyes narrowed. "And how exactly do you know that?" The man didn't smile. He didn't boast. He just answered, plain and simple. "Because I've spent most of my life studying and teaching those rules." A beat of silence. Then another. Judge Reeves scoffed, trying to regain control. "Oh, really? And what are you, a lawyer?" "No," the man said. "I'm a law professor. Retired, but still familiar with the basics." That's when the air in the room changed completely. The public defender, sitting nearby, sat up straighter. She'd been half asleep through the morning docket, but now her eyes widened. She'd seen this man before, not in court, but in a lecture hall years ago when she was still in law school. She remembered his voice, his precision, the way he could break down complex legal ideas into something anyone could understand. She cleared her throat. Your Honor, I believe this is Professor Whitmore. The judge froze. Professor Whitmore. The name didn't mean much to the average person, but in legal circles it carried weight. He'd taught constitutional law for over 40 years. He'd written textbooks still used in law schools across the country. He'd advised judges, argued before appellate courts, and once even declined an appointment to the state Supreme Court because he preferred teaching to power. Judge Reeves had never met him, but he'd read his work. More than once, for a moment, no one moved. No one spoke. The judge stared at the elderly man as if seeing him for the first time. The arrogance that had filled his voice just minutes ago was gone, replaced by something much heavier. Doubt. You're Professor Whitmore? He asked, voice quieter now. I am, the man replied simply. The judge swallowed hard. He glanced at the contempt form he'd been about to sign. His pen hovered over the paper, suddenly feeling much heavier than it had a moment ago. Outside, the world kept turning. Cars drove by. People rushed to work. But inside courtroom 3, time had slowed to a crawl. What had started as a routine traffic hearing had become something else entirely. A moment where pride met principle, and authority met humility, and it was only the beginning. The silence in the courtroom stretched like taffy, thin, tense, and ready to snap. No one moved. Even the ceiling fan seemed to slow its spin, as if holding its breath. The judge sat frozen, fingers still curled around the pen he'd been about to use to sign a contempt order against a man who, just moments ago, he'd treated like a nuisance. Now that same man stood calmly, eyes steady, waiting. Not for an apology, not for revenge, but simply for the process to continue fairly. Judge Reeves cleared his throat. It came out rougher than he intended. Professor Whitmore, he said slowly, testing the name like it might burn his tongue. Is that correct? The elderly man nodded once. Yes, Your Honor. A few people in the gallery exchanged glances. One woman pulled out her phone and started typing quietly. Another leaned over to whisper to her friend. Did you hear that? That's the Professor Whitmore? The name carried weight even if most didn't know exactly why. But those who did, like the young public defender in the front row, knew this wasn't just some retired academic. This was someone who'd shaped how generations of lawyers understood justice. The judge shifted in his chair. He tried to recover, to reclaim the authority that had just slipped through his fingers. Well, he began, voice tighter now, that doesn't change the fact that you were cited for a traffic violation, and that you interrupted court proceedings. I didn't interrupt, Your Honor, the professor said gently. I asked a question. The law allows for that. In fact, Rule 17 of the state court procedures explicitly permits a defendant to seek clarification before entering a plea. He said it without pride, without flourish, just as someone might say the sky is blue. But to the judge, it landed like a stone in still water, ripples spreading fast. The public defender raised her hand slightly. Your Honor, if I may, Professor Whitmore isn't just citing rules from memory. He literally helped draft the commentary on those rules for the State Bar Association back in the 90s. Now it was the judge's turn to go pale. He looked down at his bench notes, then back up at the professor, then at the contempt form still sitting there like an accusation turned against him. His jaw worked silently for a moment. He wanted to double down, to say something sharp to reassert control, but the room had shifted. The energy had changed. Even the bailiff stood a little straighter, watching closely. Finally, the judge exhaled. Fine, he said, voice clipped. Let's proceed with the original charge. The clerk, who'd been frozen at her desk, blinked and fumbled with her papers. The defendant is charged with failure to use a turn signal on Maple Street last Thursday, at approximately 3:15 p.m. The professor nodded. Correct, and I'd like to enter a not guilty plea. A ripple went through the room. Not guilty? Over a turn signal? Most people would have just paid the fine and gone home. But this wasn't about the fine. Everyone could feel that now. On what grounds? The judge asked, wary. On the grounds that I did signal, the professor said. The officer may have missed it. My vehicle's left blinker was functioning properly. I had it serviced the day before. And there were 2 witnesses, a postal worker and a crossing guard. Both saw me signal. The judge frowned. You have witness statements? I do. I brought affidavits. He reached into his coat pocket and pulled out two neatly folded papers. He handed them to the clerk, who passed them up to the bench. The judge scanned them quickly. Both were signed, notarized, and detailed. The postal worker even included his employee ID number. The crossing guard noted the exact time and location. It was thorough, professional, the kind of preparation you'd expect from someone who'd spent a lifetime in legal trenches. The judge set the papers down slowly. "Why didn't you lead with this earlier?" "Because I was never given the chance," the professor replied. "You cut me off before I could speak. I only mentioned the legal basis for my right to speak because you threatened contempt. I didn't want to escalate, I wanted to de-escalate. But fairness requires both sides be heard." His words hung in the air, simple but powerful. Not angry, not defensive, just true. The public defender stood. "Your Honor, given the new evidence, I'd ask that the court consider dismissing the charge, or at least scheduling a brief hearing to hear from the witnesses." The judge hesitated. He could push back. He could say the affidavits weren't enough. But he knew, if this went further, if word got out that he'd tried to strong-arm a respected legal scholar over a minor violation, it wouldn't end well for him. Judges were supposed to be above pettiness, and right now he felt very, very small. "Fine," he muttered. "Charge dismissed." A soft sigh of relief swept through the room. The professor didn't smile. He didn't gloat. He simply said, "Thank you, Your Honor," and began to gather his papers. But then he paused. He looked up at the judge, not with judgment, but with something closer to concern. "May I say one more thing?" he asked. The judge braced himself. "Go ahead. You're a judge," the professor said quietly. "That means people look to you not just to enforce the law, but to model it. When you shut someone down before they've spoken, even if they seem unimportant, you teach everyone in this room that their voice doesn't matter. And that's dangerous." He wasn't scolding. He was reminding. Like a teacher who still believed in his student, even when the student had stumbled. The judge didn't respond. He just nodded stiffly, eyes fixed on his desk. As the professor turned to leave, the public defender stood and offered him a small, respectful nod. Others in the gallery did the same. One man even stood up as he passed, a small gesture but meaningful. Outside, the sun was high. Birds chirped. The world hadn't changed, but inside that courtroom something had. A moment of arrogance had met a lifetime of integrity, and the balance had shifted. And though the professor walked away quietly, cane tapping softly on the courthouse steps, the echo of what happened would ripple far beyond those walls. Because sometimes the most powerful lessons aren't shouted, they're spoken softly, by someone who knows the law not just as rules on paper, but as a promise to treat everyone with dignity. And that promise? It applies to everyone, even judges. By lunchtime, the story was already spreading. Quietly at first, like a rumor passed between courthouse clerks over coffee, then louder, like a spark catching dry grass. Someone had recorded part of the exchange on their phone. Not the whole thing, just enough to show the judge snapping, the elderly man standing his ground, and that stunned silence when the truth came out. The video wasn't posted online yet, but it didn't need to be. Word traveled fast in a place where everyone knew someone who knew someone. At a diner 2 blocks from the courthouse, the public defender sat across from a colleague, stirring her coffee absently. "You should have seen his face," she said, voice low. Like he'd just realized he'd yelled at his old professor in the middle of class. Her friend chuckled. "So it really was him? The Professor Whitmore?" "Yeah. I took his seminar on judicial ethics in law school. He used to say, 'A gavel doesn't make you wise, it just makes you loud.' I never forgot that." Back at the courthouse, things were far less calm. Judge Reeves stayed in his chambers long after the morning docket ended. He skipped lunch. His assistant knocked twice but got no answer. Inside, he sat at his desk, staring at the contempt form he never signed. It felt like a ghost now, haunting him with what could have been. He kept replaying the moment. The calm voice, the precise citations, the quiet disappointment in the professor's eyes. It wasn't anger that stung, it was the lack of it. The man hadn't fought back with insults or threats. He just stood there, grounded in principle, and let the truth do the work. That afternoon, the local news station got a tip. Not from the professor. He'd politely declined every call, but from someone in the gallery who'd seen it all unfold. The reporter, a seasoned journalist who'd covered everything from city council meetings to corruption trials, smelled a story. Not a scandal exactly, more like a lesson, the kind people needed to hear. She called the courthouse for comment. The judge's office gave a tight-lipped statement. The matter was resolved in court. No further comment. But that only made people more curious. Meanwhile, the professor was back at his small house on the edge of town, watering his garden like any other Tuesday. He lived simply, a tidy porch, a few bookshelves crammed with legal texts and poetry, a cat that napped in sunbeams. He hadn't gone to court looking for attention. He'd gone because he believed in showing up even for small things, especially for small things, because if you let the little injustices slide, the big ones follow. But the world wasn't done with him yet. The next morning, a law student from the state university showed up at his door. She'd heard the story from her professor, who'd once studied under him. "Is it true?" she asked, eyes wide. "Did you really correct a judge on courtroom procedure?" He smiled faintly. I reminded him of the rules we all agreed to follow. There's a difference. She stayed for an hour, asking questions not about the incident but about what it meant to uphold the law when no one's watching. He spoke about fairness, about how justice isn't just in grand rulings. It's in how you treat the person standing before you, tired and nervous, hoping to be heard. That same day, the video surfaced online, not on a major platform at first, just a local community forum. But within hours it was shared on legal blogs, then picked up by a regional news site. The headline read, "Judge backs down after confronting retired law professor in court." The clip was only 90 seconds long, but it was enough. You could hear the judge's sharp tone, see the professor's calm posture, and feel the shift in the room when the truth landed. Comments poured in. Most praised the professor's composure. Some defended the judge, saying courtrooms are stressful and mistakes happen. But many asked a harder question. If this had been someone without a title, someone poor, someone young, someone without a cane and a quiet voice, would they have been treated the same? That question didn't sit well with a lot of people, especially not with the State Judicial Conduct Board. By Thursday, they'd opened an informal inquiry. Not a full investigation, just a review of courtroom decorum, as their press release put it. But everyone knew what it meant. Judges were held to high standards not because they wore robes, but because they held power over people's lives. And power, unchecked, could easily turn into pride. Judge Reeves got a call from the chief judge of the district. It wasn't angry. It was worse, it was disappointed. "You know better," the chief judge said. "We don't get to pick who deserves respect. Everyone who walks through those doors does." The judge hung up and sat in silence for a long time. Back in the community, something unexpected began to happen. People started talking, not just about the judge, but about their own experiences in court. A single mom remembered being scolded for bringing her toddler to a hearing. A delivery driver recalled being fined without being allowed to explain his GPS had failed. These weren't dramatic stories, but they were real, and now they felt seen. The professor didn't seek the spotlight, but his quiet act of dignity had opened a door. Not for revenge, not for fame, but for reflection. On Friday, he received a letter. Not from the court, not from the media, from a retired school teacher who'd been in the gallery that day. She wrote, "Thank you for reminding us that standing up for what's right doesn't require shouting. Sometimes it just takes one person willing to speak calmly in a room full of noise." He read it twice, then placed it on his desk beside a photo of his late wife. She'd always said he had a way of making people feel heard, even when they were wrong. That's the point, he'd tell her. Everyone deserves to be heard. The law depends on it. As the weekend came, the buzz didn't die down, it deepened. Law schools began using the incident as a case study in ethics classes. Local bar associations discussed it at meetings. And in courthouses across the state, judges found themselves pausing a little longer before speaking, listening a little more carefully before ruling. Because the real story wasn't about a judge making a mistake. It was about what happens when someone chooses principle over pride, and how that choice can echo far beyond a single courtroom. And the professor? He went back to his garden, his books, and his quiet life. But he knew sometimes showing up is enough. Sometimes just being who you are in the right place at the right time can change everything. The story didn't fade. If anything, it grew roots. What started as a brief courtroom exchange had quietly taken hold in the public imagination, not as gossip, but as something deeper. People weren't just talking about what happened. They were asking why it mattered. And that made all the difference. Within a week, the clip of the courtroom moment had been viewed over 500,000 times, not because it was flashy or dramatic, but because it felt real. There was no shouting, no theatrics, just a calm voice standing up for fairness in a place where fairness should have been guaranteed. That kind of quiet courage resonated, especially in a world that often felt loud and rushed. Local news stations began running follow-up pieces. One reporter interviewed courthouse regulars, bailiffs, clerks, even a few attorneys, who all said the same thing. Judges like Reeves weren't rare, but moments like this were. Most folks just take it, one clerk admitted on camera. They don't have the energy or the knowledge or the confidence to push back. So they leave feeling smaller than when they walked in. That sentiment struck a chord. Social media filled with stories from people who'd felt dismissed, rushed, or humiliated in legal settings. Not because they'd done anything wrong, but because they didn't sound like they belonged. A young man wrote about being fined for jaywalking while trying to catch a bus to his second job. An elderly woman shared how she'd been scolded for not understanding legal paperwork after her husband passed. These weren't crimes. They were human moments, and yet they'd been treated like failures. The professor, for his part, stayed out of the spotlight. He turned down every interview request politely but firmly. "The story isn't about me," he told a persistent journalist over the phone. "It's about how we treat each other in spaces meant to uphold justice. I just happened to be there." But his silence spoke volumes. In a time when everyone seemed eager to claim credit or assign blame, his refusal to grandstand only made people respect him more. Then came the op-ed. It appeared in the Sunday edition of the state's largest newspaper, tucked between columns about city budgets and school board meetings. The headline was simple: "Justice begins with listening." No byline at first, just the words. But by mid-morning, everyone knew who wrote it. In clear, plain language, the piece didn't attack the judge. It didn't call for punishment or outrage. Instead, it reflected on what the courtroom is supposed to be: a place where every voice, no matter how soft or unpolished, deserves to be heard. "The law is not a weapon," he wrote. "It's a promise. A promise that no one is too small, too old, or too ordinary to be treated with dignity." He went on to describe how, over his decades of teaching, the students who struggled the most weren't the ones who lacked intelligence. They were the ones who'd been told, over and over, that their questions didn't matter. "And if we teach people their voice has no value," he wrote, "we don't just fail them. We fail the entire system." The piece went viral. Lawyers shared it with their law school mentors. Teachers read it aloud in civics classes. Even judges, some of them, sent quiet notes of thanks. Meanwhile, the Judicial Conduct Board continued its review. They weren't looking to punish, they explained in a carefully worded statement. They were examining whether the incident revealed a pattern of behavior that undermined public trust. Court transcripts from the past year were pulled. Complaints filed against the judge were re-examined. Nothing explosive surfaced, no corruption, no bias, but a theme emerged: impatience. A tendency to cut people off. A habit of treating minor hearings like inconveniences rather than responsibilities. It wasn't illegal, but it wasn't leadership either. Back in his chambers, the judge felt the weight of it all. He hadn't slept well in days. He kept replaying the moment, not just the embarrassment, but the look in the professor's eyes. It wasn't anger. It was sorrow, as if he'd seen this before, as if he knew how easily power could blind someone to their own humanity. One afternoon, he called his old law school professor, the one who'd taught him civil procedure 20 years ago. "Did I really mess up that badly?" he asked, voice strained. There was a long pause on the other end. "You didn't break the law," the professor said gently. "But you forgot who the law is for. It's not for judges. It's for the people who walk through that courtroom door scared, confused, or alone. And when you make them feel smaller, you betray the whole point." The words landed like stones in still water. The judge sat at his desk that evening, staring at the empty contempt form again. Then slowly he opened a fresh notepad. He didn't write a defense. He didn't draft an excuse. He began listing changes, small ones but real. Longer pauses before speaking. A note on his bench: "Listen first." A plan to attend a judicial ethics refresher course even though it wasn't required. He knew it wouldn't erase what happened. But maybe it could prevent it from happening again. Outside the courthouse, the public conversation kept growing. A local nonprofit launched a Know Your Rights workshop for seniors and low-income residents, teaching them how to navigate minor legal issues without fear. Law students volunteered to staff a free legal help desk in the courthouse lobby. Even the bailiffs started greeting people by name instead of case number. None of it was mandated. It just happened, because one quiet moment had reminded everyone that justice isn't just about rulings, it's about respect. And the professor? He still watered his garden, still read poetry in the evenings, still fed the stray cat that now visited every afternoon. But now when he walked down the street, people didn't just nod, they smiled. Not because he was famous, but because he'd given them something rare. Hope that fairness still mattered. The system hadn't changed overnight. But the people in it had started to look at each other differently. And sometimes that's where real change begins. Not with a gavel, but with a glance. Not with a verdict, but with a voice saying simply, "I'd like to be heard." And this time someone was finally listening. 6 weeks after that tense morning in courtroom 3, the courthouse felt different. Not in the way buildings change, but in the way people moved through it. There was a little more space between words, a little more patience in the lines, a quiet awareness that everyone who walked through those doors carried a story worth hearing. And it all started with one man who refused to be rushed and one judge who finally learned to listen. The official outcome of the Judicial Conduct Review came quietly, without fanfare. The board issued a public statement noting that, while no formal discipline was warranted, there had been no violation of law or ethics code. They strongly recommended that the judge participate in ongoing training on courtroom decorum and procedural fairness. It wasn't a punishment. It was an invitation to grow. And to everyone's surprise, the judge accepted it without argument. Then on a crisp Monday morning, he did something no one expected. He opened court not with a docket call, but with an apology. Standing at the bench, hands resting lightly on the wood, he spoke slowly, clearly, and without notes. "A few weeks ago," he began, "I failed to uphold the standard this courtroom and this community deserves. I allowed impatience to override fairness. I assumed I knew more than I did. And in doing so, I disrespected not just one person, but the very idea of justice we're all here to protect." He didn't name the professor. He didn't make excuses. He simply said, "I was wrong, and I'm working to do better." The room was silent, not the heavy silence of tension, but the soft silence of respect. Even the usual shuffling of paper stopped. When he sat down, a few people nodded. Others wiped their eyes. It wasn't perfect, but it was honest, and sometimes honesty is the first step toward healing. Word of the apology spread fast, not as gossip but as hope, because it showed that even those in positions of authority could admit fault, and that doing so didn't make them weak. It made them human. Meanwhile, the professor received an unexpected invitation. The state's Judicial Education Council asked if he'd be willing to speak at their annual training for new judges. He almost said no. He'd been retired for years, and public speaking wasn't his favorite thing. But then he thought about all the people who'd written to him, the single parent, the veteran, the teenager who'd been talked down to in traffic court, and he said yes. The day of the lecture, the room was full. Not just new judges, but seasoned ones too, some from counties hundreds of miles away. They came not to hear legal theory, but to remember why they'd chosen this path in the first place. He didn't stand behind a podium. He sat in a chair, cane beside him, and spoke like he was talking to old friends. "You won't find kindness listed in the rules of civil procedure," he said with a small smile. "But it's woven into every fair ruling, every thoughtful question, every moment you choose to see the person behind the case number." He told them about his first year teaching law, when a student stayed after class trembling, afraid she'd flunked the exam. Instead of brushing her off, he asked what was wrong. She'd been working nights to support her siblings and hadn't slept in days. He didn't lower the grade, but he gave her time. Years later, she became a public defender who never forgot that someone once saw her as more than her mistakes. "That's what you hold in your hands every day," he said, looking around the room. "Not just the power to decide, but the power to dignify." Afterward, judges lined up to thank him. One young appointee, barely 30, said quietly, "I was scared I'd lose respect if I showed too much compassion." The professor patted his arm. "You'll lose respect if you don't." Back home, life returned to its gentle rhythm. But something had shifted, not just in courthouses, but in classrooms, community centers, even dinner table conversations. Parents told their kids about the professor who stood his ground without raising his voice. Teachers used the story to talk about integrity. Law schools added a new discussion prompt to their ethics syllabus. What does it mean to wield authority with humility? The video of that courtroom moment never went viral in the flashy, click-driven way some stories do, but it endured. It was shown in orientation sessions for court staff, referenced in bar association panels, shared quietly between mentors and mentees as a reminder that the law isn't just about winning, it's about honoring the humanity in every interaction. As for the judge, he didn't become a different person overnight, but he became a more careful one. He started arriving early to read case files thoroughly. He paused before speaking, especially when someone seemed nervous. Once, when a young man fumbled through an explanation about a missed court date due to a bus strike, the judge didn't interrupt. He asked, "What would help you stay on track next time?" The young man blinked, then gave a real answer. A solution was found. No fines, no scolding, just problem solving. It wasn't headline-worthy, but it was justice. Months later, on a sunny afternoon, the professor walked into the courthouse again, not for a case, but to attend a small ceremony. The local bar association was honoring him with a Lifetime Service Award. He tried to decline, but they insisted. "You reminded us what we're supposed to be," the president told him. As he stepped into the main hall, something unexpected happened. People stood, not because they were told to, but because they wanted to. Clerks, attorneys, even a few bailiffs. And there, near the back, stood the judge. He didn't approach. He didn't speak. He just gave a small, respectful nod. The professor returned it. Later, during the short reception, a law student asked him, "Do you think one moment like that can really change things?" He sipped his tea and thought for a moment. "Not by itself," he said, "but it can be the spark. Real change happens when ordinary people decide again and again to choose fairness over convenience, patience over pride. That courtroom moment, it only mattered because people chose to carry it forward. And they did. Years from now, long after the headlines faded and the video stopped trending, the story would still be told, not as a tale of humiliation, but as a quiet lesson in what justice looks like when it's rooted in respect. Not in robes or rulings, but in the simple act of listening. Because in the end, the law doesn't live in books or courtrooms. It lives in people. And when people choose to treat each other with dignity, even on an ordinary Tuesday morning, that's when the system finally works the way it's supposed to.